Hello, everyone. Welcome to our Wednesday webinar. My name is Brad Chaplick. I'm a condominium lawyer at Horlick, Levitt, Lella. We'll just give a brief moment for everyone to connect and get settled into the meeting, and then we'll get started. So we've got a very exciting meeting today, or subject matter today. We're going to talk initially about vaccine mandates in Ontario condominium communities. I've got a short slideshow prepared just to walk us through some of the issues and to explain our rationale as to what we think condos can and can't do. And then, as always, we'll take your questions, which you can type into the Q&A button should be at the bottom of your screen. So you can type questions into the Q&A and we'll answer those questions. But while we're before that, I'll do my presentation. So I can see people are just starting to come in, and the numbers of attendees in the meeting going up and up and up. So I'll just give it one more minute, and then we'll start the slideshow, and people can join us as we're going through the slides. So let me get the slideshow up on the screen for everyone to see, and we'll get started. Okay. So you should all have the slideshow up on your screen now, and this is our introductory slide, COVID-19 vaccines in Ontario condominium communities. So first, let's talk, what are the main areas of discussion? So people have talked about the issue of vaccines in condominiums in a bunch of different contexts. One of them is requiring proof of vaccination for contractors who are working on site. Second is employees working on site. The third, and the one we're going to focus on today, is requiring proof of vaccination for as a condition of using non-essential amenities. So you can think of things like your gym and swimming pool. And then the fourth category, and one that I think is probably not going to be permitted, is requiring proof of vaccination as a condition for visiting or living in the building. So those are some of the questions that people are asking us and that we'll investigate. So broadly, when we talk about vaccination, what are some of the reasons why we would want to have a vaccination policy or rule, and what are some of the reasons why we might not want it? So let's talk about what those factors in favor and against would be. So in favor, you're going to protect vulnerable people in our society. But on the other side of that, people have a right to privacy in terms of their medical information and medical decisions. A factor in favor is creating an incentive for hesitant people to get the vaccine. On the other side, we want to protect people's individual freedoms if they decide not to get vaccinated. In favor, the condo has a legal obligation to provide a safe living and working environment for both residents and staff. On the other side, you have to think about human rights and proper enforcement and avoiding undue legal liability. In favor, it looks like there might very soon be different rules depending on whether you have a vaccine mandate. So for example, you can avoid lockdowns or closures perhaps of certain facilities by requiring all people to be vaccinated. So a vaccine rule could be a way to keep your gym open if you otherwise might not be able to have it open. And then on the other side, there's no legal obligation to vaccinate. So do we want to insist upon something that's not legally required? In favor, yes, people have individual rights, but we want to balance those with what's in the best interest of the community. And that balance is going to be a little bit different when we're talking about a condominium because people live in close proximity to each other. So the closer you live together, the more you have to think about the communal interest. And finally, on the other side, what about the availability of alternatives? Rapid testing, health screening, physical distancing, and masks. Are these things not enough? Is it really necessary to create yet another restriction upon people because of COVID? Do we need a vaccine mandate? So these are the things that we think about, and you'll see how these issues come into play. So there's a little bit of confusion over policies and rules and when you would use one versus the other. And the big difference is that a rule is something that is clearly governed by the Condominium Act. But a policy, there's no mention of policies in the Condo Act. So what is a policy and what is a rule? So policies have different applications. They govern the board's exercise of its discretion. They oversee the conduct of contractors, employees, other people who the board is tasked with managing. They interpret your governing documents in a fair and consistent manner. So you could have a policy as to what type of conduct will be considered to be a breach of a rule that is an existing rule. And you can establish emergency or temporary actions that are necessary to ensure safety. So almost all condos have policies. They have post orders for their security guards. They might have a form that you have to fill out when you reserve an elevator for a move out. These are policies, right? It's not in the rules that says that you have to fill out this specific form when you reserve an elevator. And these are things that fall within the board's discretion. So what about rules? Well, rules govern typically the conduct of residents and visitors on the condominium property, as opposed to the conduct of the board. And so when we talk about regulating whether an employee has to have a vaccine, that's not something that would be done by a condo rule. That's something that would be done by a board policy. But when we talk about whether a resident might have to have a vaccine in order to use a non-essential amenity, in that case, we're properly talking about passing a rule in accordance with the Condominium Act and not doing it by way of policy, unless it is emergency or temporary in nature, such as in 2020, policies prohibiting residential renovations, non-essential renovations, were upheld by the court on a temporary basis, even though they weren't passed by rule. So that gives us an idea of what we're talking about when we say, is this a rule or is this a policy? What do we mean by a rule? So some important features of condominium rules, and this is all from Section 58 of the Condominium Act. So has to have a valid purpose. Promoting safety is a valid purpose. And of course, the purpose of having a vaccine mandate for your non-essential amenities would be to promote safety. Reasonableness. Rules must be reasonable. This is where most of the analysis will take place, is what would be considered to be a reasonable rule. And some other features of all rules, they must be consistent with the bylaws declaration of the Condominium Act. Notice, you have to give owners at least 30 days notice before the rule becomes effective. And we'll talk about whether in order to be reasonable, would you have to give people more than 30 days to get vaccinated. Requisition rights. Owners can requisition a meeting to vote on a proposed rule before it comes into force, and might also vote to amend or repeal a rule. So owners have democratic rights when it comes to the rules, which are not the same when a board passes a policy for the reasons that we've previously explained. And enforcement. Rules are legally binding on residents and visitors, and the corporation has a legal obligation to enforce them. So this is an adage that's true of all laws, but will be applied equally to condominium rules, which is don't pass a rule unless you're prepared to enforce it. So if you're thinking about creating a vaccine mandate, then realize that you're going to have to take steps to enforce it and stop people from using the amenities if they're not vaccinated and all these things. Do you really want to be doing that? And if you don't want to be doing it, then the rule is not right for you. So getting to the heart of our issue, is a rule that requires proof of vaccination to use non-essential amenities, and let's assume that we're talking about things like gyms and swimming pools, recreational facilities, is this reasonable? So lots of things to think about. Who is this rule going to apply to? Are we going to be requiring proof of vaccination from our residents? What about visitors, if they're going to use the amenities? Is it just going to be people 18 years and up, or are we going to involve children in this? And do children have additional rights to privacy because they're vulnerable above and beyond that of adults? So these are difficult questions. And if it were up to me, I would probably restrict the scope of any rule to adults age of majority, 18 plus, because first of all, if you're under 12, you don't have access to the vaccine. And if you're 12 to 17, you may have additional rights, and you might have additional concerns about taking a vaccine as a young person. So these are all things we want to think about. Human rights exemptions. So of course, there will be a small number of people who cannot take a vaccine for medical reasons, such as anaphylactic allergy. There might be other medical reasons not to take it. I'm not a doctor. I'm not aware of what those medical reasons might be. And we have to think about what kind of medical conditions would qualify and how are we going to confirm that if someone says that they have a medical condition, but it doesn't appear to be contraindicated to taking a vaccine. How are those decisions going to be made? And then what about religious objections to receiving the vaccine? I'm not a master of theology, and I don't know what religion has to say about COVID-19 vaccines, but if someone claims a religious objection, how are we going to evaluate that? What kind of proof are we going to require? And these are difficult questions that will require boards to diligently implement these rules in a manner that is consistent with the Ontario Human Rights Code, just as is true for all rules. So nothing special here. Same is true when we talk about rules for pets, and it doesn't stop us from passing pet rules. Which amenities would the rule apply to? Are we going to say only indoor recreational facilities, all indoor amenities, all amenities including outdoor? It's going to depend on your individual circumstances. So that's going to be specific to each condominium building. How much notice? So we talked before about the fact that you have to give at least 30 days written notice before a rule comes into force. But are we going to give more notice because people need time to go out and get the vaccine, and you need a certain amount of time in between shots if you're getting a series of 2 shots? So do we need to give people more than 30 days? How much more time? We want to think about that. How will the rule be implemented? Are you going to ask people to provide a copy of their receipt that they received from the Ontario government when you're vaccinated? Is an attestation that someone is vaccinated sufficient, a sworn affidavit or something like that? Are we going to use some future vaccine passport from the federal government that's intended for international travel that doesn't exist yet? And how are we going to protect people's privacy and their medical information to make sure that people's privacy rights are being respected? And finally, this is a big question, would you take proof of a negative COVID-19 test as an alternative to proof of vaccination? And that might differ if you're talking about employment versus amenities and how you structure your rule. And again, different condominium corporations will come to different conclusions, and there is no one way to do these rules. There's going to be different rules for different communities based upon your specific circumstances and the sentiment of your community. So how do we come up with an analogy for a brand new rule? And what's our best comparison? And when I turned my mind to this issue, the best comparison to me was smoking rules, because these came out relatively recently when the federal government legalized recreational cannabis. A lot of condos turned their minds to passing rules that prohibited what was otherwise a lawful activity, and you got a lot of cannabis rules, no smoking rules being passed together. And so condos seized upon the issue of cannabis and actually banned all smoking. And this happened in 2018, 2019. You saw a lot of these rules. And now you see the cases that came out immediately after these rules. So we have this case, Zilberberg, from 2019. And the Zilberberg case is about smoking on a balcony. So the condominium corporation sought to enforce this rule. The unit owners, this is what the case says, were smoking on their balcony, and they challenged the validity of the rule, saying that there was no proof that smoking on balconies was harmful to other residents. And the court said that there was clear legislation and restricting smoking, and that it was reasonable to put restrictions on smoking in condos, and that this specific rule was reasonable because the Silberbergs were not left without options. They could smoke inside their unit, but they could not smoke on the balcony where the smoke would spread and be disturbing to others. And so because they had this opportunity to smoke in their unit, and because it was passed by rule, which owners had an opportunity to requisition a meeting and vote on or vote down if they weren't in favor, then the rule was reasonable. And so this raises the question that if condominium corporations are going to require proof of vaccination in order to use non-essential amenities, is that enough? Or does there need to be some reasonable alternative to proof of vaccination, such as a negative COVID-19 test? And we don't know the answer yet as to whether you need to have a COVID-19 test alternative to make your rule reasonable, but it might depend on how you frame your rule, which amenities you're referring to, and I have a solution to this issue, which I think will save condominium corporations the sort of cumbersome difficulty of having to deal with negative tests, because that's not what you want. You don't want to have to deal with proof of vaccine or a negative test. You want to just say proof of vaccine. And the question is, how can you do that? If you were to include proof of vaccine or a negative test, in my view, your rule would almost certainly be reasonable. But the question is, could you do it without it? So, some takeaways. A board of directors does have the discretion to create vaccine policies for contractors and employees who work on site. The details of those policies are going to differ from building to building, but you can have some kind of policy, reasonable, complies with human rights code, that says you need to be vaccinated to work on site. A vaccine mandate for the use of amenities should be by rule, in our view, and should be limited to non-essential amenities. So in our view, you shouldn't have a rule that says you need to be vaccinated in order to enter through the lobby, and anyone who's not vaccinated needs to take some sort of alternative entrance. That's not what we're trying to do here. We're talking about non-essential spaces, recreational facilities, things like that. Requiring a negative test can be cumbersome. What's a balanced approach? So this is what I was alluding to before. In my view, at this time, at least, one solution that we've come up with is to have special amenity hours, which would be reserved only for residents who have provided proof of vaccination. So outside of these hours, anyone could use the amenity, and there could be even a cleaning protocol in between the general hours and the vaccination only hours. And to my mind, this is a really clean solution, because now someone who chooses not to be vaccinated has options, right? They can use it during the other time. And it also relieves a lot of the conflict that might come up with sort of like bogus exemptions, right? So someone comes to you and says, well, I want an exemption from the vaccine rule, and I want to be able to use the gym because I have this other thing, and I've got an objection to taking vaccines. And now if you say, well, you can use it during these other hours, you don't have to really deal with that. You can just say, well, look, no problem. Use it during these hours when you don't have to have the vaccine. And that's your answer to anyone who is wanting an exemption or challenge you on the rule. And I think it makes the rule much more reasonable. So your rules should be drafted by an experienced condominium lawyer. They need to be customized to your community's unique needs. This is not going to be a one-size-fits-all rule. And remember that because we're so early in the world of like vaccine passports, and there might be legislation coming from future either federal or provincial governments about these kinds of things, either requiring vaccine mandates perhaps, or not allowing them. We don't even know which way the government could go, or if they'll sort of keep the status quo. That any rule that you pass now, if the government changes the law on us, as they're so fond of doing when it comes to COVID regulations, sometimes every week, we have to be prepared to amend our rules and respond accordingly. So that's my slideshow. So I hope everyone liked that. We're trying to provide you with some helpful answers. And now we're going to go to some of the questions. So let's go to the Q&A. And then I see a couple people have written questions in the chat, which I'll respond to as well. So let's, we'll just go through, I see some hands up, but we'll try to do the questions in writing if we can, just to keep things organized. I see I got about 9 or 10 questions lined up here after that 15-minute introduction to the issue. So Attila asks, question regarding the possibility that the corporation may make mandatory pest control treatment at all units where some owners refuse access. If pest control mandatory for all units would have to be, in my view, in response to an active infestation. And if you had proof of an infestation in a particular unit, you would be entitled to take reasonable pest control measures if the unit fails to do so within a reasonable period of time. There is case law on pest infestations. You deal with it in Section 92 of the Condominium Act. I'm not sure that you could require all unit owners to do pest control in all units, which is not an area where the condominium corporation has the obligation to maintain and repair if there was no proof of any infestation. So it's going to depend on your circumstances, Attila. Excellent question. Jason asks, we are using staffed amenity hours to control access to gym, tennis, barbecue. Otherwise, they are closed. Other condos are not doing this. They're simply posting COVID capacity limit and providing a sign-in, sign-out sheet for contact tracing. Are we being too strict? Are they being reckless, putting themselves in potential peril? So Jason, this is a good question. The condominium manager has a legal obligation under the emergency orders for COVID-19 to ensure that things like capacity limits are being followed. So if, as a condominium manager, you're just posting a sign and you're not doing anything to enforce, and the capacity limits are not being followed, and there's a complaint or an inspection, then you could be fined. And so I don't think you're being too strict. I think that amenities do need to be monitored to make sure that things like capacity limits are being followed, and there's different ways to do it. And it seems that the way that you're doing it is just fine. And for people who are not taking any steps to enforce, I think, yeah, to a certain extent they are. They're taking their chances or playing with fire, however you want to put it. Yeah, Jason, I think you're doing the right thing. Catherine. Catherine says, I apologize if I may be insensitive or touching on a sensitive area, but I really don't understand why our children, when they go to school, have to have their vaccinations for MMR, etc. If we don't have proof of vaccination, they cannot attend school. How does this differ? Well, Catherine, it doesn't really differ. And you're right, we do require proof of vaccination to go to school and engage in a civilized society. And I was also going to mention the fact that I was doing a little bit of reading about the history of polio and how a lot of the public health regulations that we have relating to swimming pools, for example, arise from the need to eradicate polio. And it is extremely common for us to, as a society, to adopt laws and rules requiring public health and safety and vaccination to prevent the spread of disease. So you're right, Catherine, there is not a big difference. The only difference in this case is that it's a new vaccine, and so not everyone has taken it. But if I think in 5 years or something, if a COVID vaccine becomes part of a basic vaccine regimen given to people by their family doctor, then there will be no controversy surrounding these things. But it's because we're introducing a brand new vaccine to the entire population at once, it presents a new challenge. That's really the issue. Another question here from Attila. Scenario, water escape results in damage at multiple units due to an owner allegedly doing plumbing repairs at a faucet. Okay. What are the chances that the corporation may charge back the entire amount for the remediation and repairs to the respective owner? The board considers the owner's actions negligence. Management has notified that it has notified that it is an error omission and only the deductible may be charged back. Attila, the manager is right. So the question is, what can you charge back when a unit owner negligently breaks the faucet and causes a huge flood? And the answer is the maximum amount that you can charge back to the unit owner who negligently caused the damage is the amount of your insurance deductible. You cannot charge any more than the insurance deductible. And then in that case, only if you would have a insurance deductible bylaw. So there are two criteria, only up to the amount of your deductible and only if you have an insurance deductible bylaw. Otherwise, it's dealt with by the corporation's insurance, and the deductible is the condo's responsibility for damage to common elements and other units. See section 105 of the Condominium Act. Great question, Attila. Another question from Attila. What medical letters would be acceptable to allow a dog in a no dog building? Oh my, you would just be relying on a, I assume you're talking about emotional support animals and not something like a service animal, like a blind person's seeing eye dog or anything like that. So if you're just talking about emotional support animals and that in a no dog building, then you would basically accept, in most cases, a standard letter from a doctor saying, I am Dr. So-and-so. This resident has been under my care for however many long. The resident has an emotional support animal to deal with a known medical condition, and you wouldn't be prying into the exact details of the diagnosis. You would rely on the doctor, and you would accept that most of the time. That's what you do. But I don't have like a list of medical conditions that are acceptable versus those that are not. It's up to the doctor to decide. And generally speaking, as condominium managers and boards of directors, we do not want to second guess the doctor's determination because it's not our place to do so. Patricia says, this is a hornet's nest. Who is going to enforce this? The pool guy, the property manager? How are owners to requisition a special meeting to exercise their democratic rights during a pandemic? Yeah, Patricia, it can be a hornet's nest to enforce rules, especially rules that require people to do things as a condition of entering the amenities. Who's going to enforce it? Well, yeah, you'd have to have a way to enforce it. And I have a 3-page article where I talk about these issues. And one of the first issues I mentioned is you have to have some mechanism in place to be able to enforce these rules if you're going to implement them in a reasonable way. Maybe it's, people's fobs need to be programmed according to their, having complied with the rule. And in terms of requisitioning a special meeting, people can collect signatures from other owners, and it does happen. And we do receive requisitions within the last 18 months. And then you have the meeting electronically. So yeah, Patricia, it's tricky stuff. Attila asks, will you share the slides? Yes, you can send me an email, bchaplick@hldlawyers.com, and I'll send you the slides. And also when we post the video on our YouTube channel, because this seminar is being recorded, I will also post the slides and the article in the video description below the video. So we'll post the article, we'll post the slides online next to the video. And if you want an email copy of PDF of the slides, send me an email, bchaplick, bchaplick@hldlawyers.com, and I will send them to you. Anonymous question, how will cleaning protocols be affected during unvaccinated and vaccinated booking? Well, I think what you would do is you would, let's say you're doing it for a gym, is you would say, okay, the gym is open from 10 to 2, and then the gym is closed from 2 to 2:30, and we do a cleaning of the gym, pretty thorough cleaning, and then it reopens for a reserved vaccination period of 2:30 to 4, and then it's open for everyone, something like that. That's how you do it, but there's different ways to do it. Patricia says, Canadian Civil Liberties is already bringing legal challenges against various provinces for their COVID laws. This is a lawsuit or 10 waiting to be filed. Maybe so, Patricia, but as a lawyer, I'm not dissuaded by things like lawsuits, and I'm happy to to pass rules that I think are reasonable and people think I'm wrong, then you get a lawsuit, just like you did in Zilberberg, and the rule was upheld. So I think I can pass reasonable rules, and if people want to bring lawsuits challenging that, I think I'm happy to defend those lawsuits. Patricia says, smoking is a poor comparison. How can you swim in your condo unit? Unit owners are paying to use an amenity now, and you are going to deny them this use unless vaccinated. Are you suggesting the condo boards give a rebate on condo fees? No, I was suggesting that they have separate hours. Thanks, Brad. What do you think about guest suites? Guest suites are a little bit different, I would say, because it's not a communal thing the way the gym and the pool is. So I would say that there might not be the same need for a vaccine mandate on a guest suite, but if I'm open to being corrected about that. But I think a guest suite is something a little different than an amenity that is open to all people from all different households using it at the same time. And the same thing might also be true of renting the party room, right? When you rent a party room for a private event, it's not being used by members of different households from within the condominium at the same time. And while that event might itself lead to the spread of COVID, it's not something that would affect necessarily all the other owners of the building. So you do have to consider the specific circumstances of different amenities. And the questions just keep coming. Oh my goodness. Okay, hold on one sec. We're going to go to the chat and see if there's just a couple questions in there that we can clear up, because I think they've been in there for a while. We have a question here. Even without requiring proof of vaccination, what is the corporation's responsibility with respect to monitoring behavior and amenities such as party rooms and meeting rooms, masking, distancing, etc.? So this is similar to another question we got. The corporation's property manager is ultimately responsible for ensuring that the amenities are being operated in compliance with step 3 emergency orders. And so you should monitor them. I'm not saying that you need to monitor them constantly, but there should be checks and proof and records of checks being done. Maybe you go and you check in every hour, 2 hours, whatever is necessary to make sure that the capacity limits are being followed, and you keep a record that you've been doing those checks so that if you're ever questioned about it, you can show it. So Raj asks, if we stagger the time between vaccinated versus non, do we need to sanitize each time or day? Also, can we get a presentation via email? Okay, yes, I will send you the slides via email. Also, the video is going to go up on our YouTube channel. And I think, yeah, we're talking about sanitizing in between potentially, but you would be doing that anyways. You would be, in any event, if you have your gym, you're going to be closing it, throughout the day to engage in sanitization as part of just general compliance with step 3 rules, which requires you to operate these facilities in a safe and sanitary manner. So there you go. So it's something you're doing anyways, ideally. Okay, I've got 19 questions in my queue. So I'm just gonna go through them as quickly as I can. And we'll see if we can go for another half an hour or so. Noel asks, are there particular requirements for cleaning or distancing in non-essential amenities due to a condo, due to COVID-19, such as a gym? Are these the same requirements as in a commercial gym? So the regulations are woefully inadequate when it talking about condos, and they mostly talk about businesses or other facilities. So presumably this includes gyms that are shared but are not commercial, and they do not seem to have different rules for different commercial versus condo gyms. They don't specify like how often you have to clean. They say that you need a safety plan, and they say that it has to be adequate. That's basic. So that's your answer, is that there are not particular requirements, but there are requirements that are up to you then as the manager or board of directors to interpret and implement. So, and if you're not able to do that, then the answer is you really can't open these amenities unless you have an effective plan for how you're going to comply with these rules. So let's see here. I think I missed a question. Okay. How would you enforce, this is an anonymous question, how would you enforce no smoking rules or dictate who can utilize the facilities in a private condominium park space? I misread that initially as parking, but you're saying park. So how would you enforce the no smoking rules or dictate who can utilize the facilities in a private condominium park space? So like an outdoor landscaped park. Well, for no smoking, you could have it on a complaints-based system. And you, so basically someone would say, I'm complaining about smoking in the park, and then you have if you have security, you go out and look. If you have security cameras, fine. Otherwise, it's just complaints based. You're not, or you're patrolling, but maybe your security guard might only patrol a couple times a day. That's not really effective, but it's complaints based. And then how can you dictate who would use the facilities outdoors? If it's not a controlled area, right? If it's not something that you need like a key to get access to, then you really aren't going to be able to control who can use an outdoor park. And that's why I don't recommend having a mandatory vaccine policy for your lawn or something like that. It's not practical. I'm talking about things that we can practically possibly implement, right? So, good question. What liability is posed on a condominium corporation in requiring vaccination for employees or contractors in the event that an employer contractor gets a rare side effect from the vaccination? I'm not certain that you would be liable for a rare side effect from someone taking a vaccine. I don't see how that fault could be placed upon the condominium corporation. So to me, that is not a concern that would stop me from implementing that policy. I think people understand that there are rare side effects when you take vaccines, just as there are rare side effects when you take a lot of approved medical drugs and things like that, and people have to weigh those risks. We have an occupancy bylaw, older building, PM asks, that does not outline the fees to be charged and the age limit. Okay, I think I know what you're saying, but I'm gonna have to make some assumptions here. So an occupancy bylaw, for everyone listening, is in section 57 of the Condominium Act. It says you can pass a bylaw limiting the number of people who may occupy a residential unit, and that it can't be less than what the law allows for. So some people take that and interpret municipal bylaw and Ontario Building Code as 2 persons per bedroom or sleeping area. It's a question of whether other rooms can get counted, like dens and things like that. And it's saying it doesn't talk about the age limit. So do you count children? I don't like to. I usually like to count adults. And then it doesn't talk about the fees to be charged. So what happens is if someone violates the occupancy standard by overcrowding the unit, you're allowed to increase the maintenance fees. And the occupancy standard bylaw doesn't say by how much you would increase the fees. The answer is it sort of depends on what is included in your common expenses and what's not. If all of your utilities are included, like water and electricity are included in your maintenance fees, then I think you can increase them a little more than if amenities are separately metered for each unit. Because if amenities are separately metered for each unit, then the fact that the person has more people in the unit and is using more water, if they pay for their own water, that's not something that you can charge them more for. So it's going to depend in your older building as to what's included in your monthly maintenance fees, and you might have an engineering report that gives you a reasonable estimate, and you'd base it on that. So that's how you do it. Great question. Question here: what would be a reasonable charge that the board can charge? I've done this before, and I think we had some utilities that were included in the monthly maintenance fees, and we charged a 10% increase in monthly common expenses for every adult over the occupancy limit. And that's what we did. It's going to depend on your circumstances. Anonymous question: does tenant allow to enter into residential sublease agreement who is subleasing the second bedroom for this term of 6 months for another person, even by having owner's written consent? This tenant lives in the building for about 5 years. If you do not have any rules about subtenancies or short-term leasing, and you're just a regular condo with no rules about that, and the tenant is subleasing and has the landlord's consent, the tenant has a right to do that, and I don't see why the condominium corporation would take issue with it. So not a problem in my view that a tenant sublets unless you have rules that prohibit it. In the absence of a rule, it's fine by me. Eleanor asks, are there any legal issues with keeping a copy of an ID from a resident? Say they lost the key and require access to their unit using the master key. Well, I mean, there's privacy issues, and you have to keep that information safe. So in that sense, there's a legal issue, but people do it. Another way people do it is they have their own computer system which links a particular fob or unit to a photograph of the person, which is taken by the security staff. So they come in and you say, well, I want my building fob. And they say, okay, great, we're gonna take your picture, boom. And then that fob is connected to a picture of a person. And so when the person swipes their fob, up on the security guard's screen pops up a picture of the person, and he can look and say, that's the person, that's the picture, it's a match. We don't have a stolen fob situation. So stuff like that happens. And I think if you're trying to create something like that, you're within your rights. As to the second part of your question, excuse me, which is giving access to someone's unit using the master key, I would probably want to have a policy that says you're not going to do that. And there's a variety of legal reasons why, because people like get the locks changed on them and things like that. And then you go and you give access and maybe you were not doing the right thing. So I would be hesitant towards providing the service of letting people into their unit. If they lose their keys, I would tell them to go get a locksmith. But you know, I know condos do it all the time, and it's a common practice, but it's not one that I'm particularly enamored with. Mondeo Springs property manager says, during emergency investigation, water escape, and our staff use of cell phones for pictures and video documentation, are we breaching any type of privacy? Not in my view. Are we able to do this during our investigation? Yes, and I would encourage it. I have posed this question more than once, especially from the source unit who does not want to be held responsible. So this is pretty standard, I think. Like if you're in a situation that you would take photographs of damage from water, and most people have cameras sitting in their pocket all the time, it's on your cell phone. So of course you're going to use your cell phone to take the photographs. And you're going to record videos, and because videos can often provide more detail than a photograph, and I don't think that is a problem. If you're in someone's unit recording, you want to tell them that you're recording, and they might say they don't want you to do that. But you know, certainly if you're in the common areas, in the hallways or anything like that, that's not a private space. But if you're going to record in someone's unit, I think you'd want to make sure that you're not recording secretly. Don't record secretly. Say, hey, I'm going to take some photographs of the damage. And if someone says, no, I don't want you to do that, then, you know, we'll try to figure out why they don't want you to take a photograph of the damage. But if you're going to be held responsible for damage or water damage and be expected to repair, I think there's a reasonable expectation that you would take photographs. Raj. Hello there. If we stagger, oh, this is the same question. I already asked this. Answered this. It was in the chat before. Okay, thanks, Raj. Another question. If a resident chooses not to follow posted rules regarding mask wearing, social distancing, number of people in an elevator, what recourse does the condominium corporation have against this resident? Well, condominium corporations are required to have policies in place for these things that comply with municipal bylaws and the Ontario emergency orders, and you're required to enforce the compliance with these things. And so what I would do is I would refer the matter to the condominium corporation's lawyer to send an enforcement letter. And then if your declaration allows it, I would have the cost of that letter charged back. But this is only after other steps to achieve compliance were not successful, such as having the manager send a letter requesting compliance. So someone is persistently not following mask rules, they do not have a valid exemption, they're breaking the law, they can be ticketed by municipal bylaw enforcement. That's not really good enough for your purposes. You're going to send them a letter as the manager. Failing that, you're going to send a legal letter and hopefully charge back. That's what you're going to do. Jyoti, hi Jyoti. What does she ask? If a resident claims that he or she is exempt due to health reasons, can we restrict him from getting on an elevator with passengers? Can we post a notice to make this effective? I'm assuming that this is pertaining to masking. So there is a case called Mitrovic, and the Mitrovic case was about a resident who claimed to have, or two residents really, who claimed to have medical exemptions that did not require them to wear masks in common areas. And the court held that the medical exemption needed to be respected, but that the use of the common elements would be restricted. So there was a trade-off there. And so the residents who claimed the medical exemption, they were restricted to using only going directly to and from their unit to their car and outside using the most direct available route. And so I think you could also place relevant restrictions on such a person to say, okay, you have a mask exemption, but you cannot enter an elevator without a mask on if someone else is already in the elevator. I think that's totally fine, based on the Mitrovic case. Another question here. Are there any active cases currently involving someone challenging mandatory vaccination requirements in a condominium? What level of court did this go to? I'm not aware of any cases because I actually don't, I think condos are just now starting to turn their mind to this issue. And so, because you have to think about the timing, right? Vaccines have only been widely available to all people, all eligible adults, for a relatively short period of time, only a few months. Before that, you had to be a certain age to get the vaccine, and it was, I think, correctly understood that you would not create a vaccine requirement when the access to the vaccine was so restricted and there was more demand than supply. But we've sort of tipped over that threshold now where we have sufficient supply and anyone who wants to get vaccinated can get it. And so just now, this is why the question of mandatory vaccine requirements is coming up. And I don't think there are any court cases, or if there are, I'm not aware of them. But this is why we're talking about it, because now is when condos are making these decisions. Mark asks, we are now in the writ period of a federal election. I know there are a few buildings who are still not allowing visitors. Not sure that's even legal. Can a condo corp refuse entry to canvassers due to COVID restrictions? I don't think so. You are right, Mark. There are provisions in the Federal Elections Act, and I believe also in the Condominium Act, that say you must allow entry to certain political canvassers. There are rules about, like, they have to provide you with like ID and show who their party they're affiliated with, all that kind of stuff. I don't have all of the details off the top of my head, but you cannot refuse entry to a political candidate who wants to canvass the building. So you're right, Mark. Vanya, is there anything you can do if your staff refuses to be vaccinated? Superintendents, cleaners, etc. Okay, so we want to talk about the difference between employees and contractors. If it's a contractor, then you're going to look at the termination provisions in your contract, and you can terminate the contract, right? If it's an employee, we want to talk about union versus non-unionized. Let's assume that we're talking about non-unionized employees. And you can terminate a non-unionized employee without cause at will in Ontario, but you might have to provide notice or pay in lieu of notice. So to answer your question, if you have an employee and you say to that employee, let's say it's your superintendent or someone else who's on site, we're going to require that you be vaccinated by a certain date, and the person does not have a human rights exemption, then you could potentially terminate that employee. And whether you would have to pay salary in lieu of notice is an interesting question. That will depend on the circumstances of the termination. And I don't want to speak in generalities because each case is going to be a little bit different, but yeah, I think you could terminate. Joel, have any condos attempted to adopt a rule about vaccines, and what has happened? We're just starting to do it now, Joel. And so we haven't got any requisitions or any like opposition to it yet, but we're in the early stages of it. So that's what we're talking about it, and that's what's going on. And you know, our firm is starting to draft these rules because we're getting the requests coming in. Hi, Brad. Very slow leak from the shower into the unit below damaged the electrical panel of the unit below. Okay. Owner of shower moved in 4 months ago, says they're not paying for damage that may have been there before they moved in, but was just discovered. They will fix the shower, but they do not want to pay to repair the unit below since damage could have happened way before they moved in. What does the PM do in this case? Wow. So this is not the normal issue because the question is, can you even establish that it was this unit owner when the damage happened? I guess, you're gonna have to look at your facts, right? You're gonna have to say, like, when did the damage to the electrical panel happen? And if you can date when the electrical panel was damaged, like if it's identifiable, then I think you would proceed. And if you can't date it and someone says, well, my electrical panel is damaged, and you don't know, hey, like, was it damaged now or was it damaged 2 years ago? Then I don't think you can hold the new owner responsible. So it's going to depend on your facts. This is what you would do in this case is you're going to do the best you can to investigate the facts and circumstances and make a decision based upon the information that you have. But if you cannot establish that the damage was caused from the unit above, and they said, well, prove to me that it wasn't from the person before me, and you can't, then I don't think you would charge back. I think you'd have to err on the side of caution and only charge back if you've got reasonable proof that it was caused by this person. I mean, what else can you do, right? Banya says, my board thinks we have the right to ask them to be vaccinated. I agree. This is talking about employees. Garth asks, for employees that choose not to vaccinate, is there any leverage to ensure disclosure to residents before they step into an occupied elevator with residents or attend a resident suite? It seems we are knowingly posing a risk to our residents. So, I mean, you're not going to have someone wear like a sign on their forehead that says unvaccinated, so because you want to respect people's medical privacy to a certain extent. So I think what you would, if you are, as an employer, if you are going to pass a policy that says to work on site, you must be vaccinated, and someone does not comply with that policy, then you're not going to let them work on site. You're going to say you have to work from home or work in a back office. You can't have any interaction with residents. And if that doesn't work, then you're not, okay, let me back up. Either you're going to create a policy and everyone who has interaction with residents is going to be vaccinated, or you're not. If you're not going to create the policy, then you're not going to treat unvaccinated employees any differently. You're only going to treat them differently if you have the policy that requires them to be vaccinated. Does that make sense? I think it does. Carolyn, what's up? I'd suggest that smoking is a perfect example, as it is a health issue that basically comes down to competing rights, as does those who are vaccinated versus those who have chosen not to get vaccinated. Thank you, Carolyn. I also think it's a good example because it literally involves blowing something dangerous out of your mouth that can harm other people. Raj, also, I understand the city needs to be called 14 days prior to opening our amenities. Does this apply to a condo? It applies to your pool, Raj. It's a City of Toronto bylaw that says if you have a pool that is swimming pool that is closed and you reopen it to the public, you need to notify the public health inspector 14 days before you reopen, and that is what you are referring to. I don't think it applies to gyms. Michelle asks, can the corporation pass a rule mandating all contractors that work for owners as well as for the corporation be vaccinated? Okay. Michelle, you're clever. You thought of something I haven't thought of yet. Okay. So you wouldn't need to pass a rule to say that contractors working for the corporation be vaccinated, because that is something within the board's control anyways. That's why we talked about rules versus policies. But could you pass a rule saying that an owner, if doing renovation work in his or her unit, must only hire a contractor that has provided proof of vaccination? I guess you'd have to say, well, is the risk to other owners present in that circumstance? I'm not sure that it's like a sufficiently serious risk. I mean, it's different than the amenities, right? In the amenities, everyone's using the amenities together. I would avoid such a rule, Michelle, because I think it's not any different than requiring that visitors be vaccinated in order to enter someone's unit, or that a resident be vaccinated to enter their own unit. And I think that is something that that the law probably does not allow for at this time. We're talking about non-essential activities, and that's where we're focusing our attention in terms of controlling access. We're not talking about access to individual units because other unit owners are not affected in the same way. That's going to be my position on that. So I would say to try and stay away from the restricting vaccination for people entering owners' units. Anonymous question. What would be the best method for determining that the occupancy limits were breached by a unit? You would have a rule taught that says that all residents must be registered with the corporation. And if someone fails to register all their residents, you would require them to comply with that. And then if the number of residents exceeds the occupancy limit, you would know. That's how you do it. Robert Buckler, what is up? Okay, question from Robert. Is a valid policy versus rule to charge owners an extra fee who install or have portable air conditioners in a unit? What about charging owners a fee to properly install a window AC? This is in light of the window AC installed in a TCHC building that fell in 2019 and killed a child. I'm aware of that case, Robert. It's very, very tragic. Thank you for an amazing session as always. You're very welcome, Robert. So kind. Okay, so when you say charge an extra fee, what you're talking about is common expenses. And there is a old case from like the 80s where a condominium corporation tried to pass, I believe, a bylaw which said that if your unit was rented, then they would charge an administrative fee because of the extra time that it requires management to deal with tenants. And that bylaw was struck down as contrary or inconsistent with the declaration, which sets out what people have to pay in terms of common expenses. So I would say you cannot charge a fee for the additional electricity of a portable air conditioner, the same way that you wouldn't be able to charge people who are like Bitcoin mining in their unit if you decide to include electricity as a common expense. So if your condo has electricity as a common expense, that's what it is. People can use the electricity. If you don't want it to be that way, then amend your declaration so that electricity is individually metered, solves your problem. That's what I would do. And then window air conditioning units, if they're dangerous and you're worried about them falling on people, you just pass a rule saying no window air conditioners. That's the better option. And I think that would be fine. Most condos have that rule anyways, because they're unsightly. And if they don't, they should. Okay, another question. We've got the queue down quite a bit in the questions here. Wouldn't it be better to wait for the government to develop standards of proof of vaccination rather than going through all the procedures when it may need to be changed anyhow? Yeah, look, if you want to wait until the government has created a vaccine passport for international travel and then go and use it then, sure. But things are changing fast because I think you can see other provinces in Ontario, and maybe Ontario soon will start having all sorts of vaccine mandates. And you're looking at, major employers, civil servants, the banks, Toronto Police, all these people are implementing vaccine mandates now. And so that's why we're talking about it. We're talking about it because it's happening everywhere you look. And people want to know, how does this apply to condos? And so I'm here to answer that question. But I'm not telling you that you have to do it. You'll make your own decision. Can we put in place restrictions for political canvassers, for example, not to use the elevators certain hours? Access is still being granted, but keeps out much used common elements. The law as to what hours they can access is already in the statute. So I don't think you can make the hours more restrictive than what they are by statute. For allowing access to political canvassing. Would you say not to use the elevators? I'm not sure that I would. I would leave the political canvassers alone for now. It's a short-lived problem, so we'll just let the people do their thing. We have 2 superintendents employed by corporation, been here 10 years and over 70 years old, I'm assuming. How do we let them go without being sued? What are the ramifications for the condo? The answer is you have to pay separation money. You have to pay the money. That's How do you let go of a superintendent who's worked for you for 10 years? You terminate them without cause and you pay them amount of money equal to the amount of notice that they are entitled to, either in their employment contract or by common law. And that's going to depend on age, length of service, disabilities, and a whole variety of other factors, and specifically the wording of your employment contract. But you pay the money. That's how you do it. And if you reach a settlement, then you don't get sued. And if you don't pay them enough money and they sue you, then you get sued and you defend it. Slow leak follow-up. Who pays? Does this become an insurance issue between the parties? Damaged unit not willing to pay. Okay. Who pays for the damage to the electrical panel in the unit below from the unit above? You are going to, if you have a standard unit bylaw, you're going to see if the electrical panel is part of the standard unit. If it is, the condominium corporation or its insurer is going to pay to repair the damage. And if it is not part of the standard unit, if it's considered part of an improvement, then the unit owner or the unit owner's insurer is going to pay. And that's why we have standard unit bylaws. Wow. All right. If you are holding an AGM on Zoom and the meeting is already 30 minutes underway and the auditor has presented and people show up late, do you have to let them in? This is disruptive. They've missed most of the important terms. Do you have to let them in? Well, I would let them in. I don't know if you have to. Do you have to? I think you do. Why? Under what authority can you refuse to allow a person who would otherwise be entitled to be there into the AGM Zoom meeting? Why is it disruptive to allow someone into a Zoom meeting if they come in and they're muted? I don't think it's disruptive. I would let them in. I don't see any reason why you wouldn't or couldn't. I don't think you have an authority to exclude them. So let them in. Vaccinated as well as unvaccinated people could still get infected and they both spread the virus. Vaccinated people are protected and should have faith in the protection the vaccine provides. Both vaccinated people and unvaccinated people have owners' residence rights or not. Okay, so this is a great question. So the argument being presented here is, why do you need to have a rule that says only vaccinated people are going to use the gym during these hours? Shouldn't the vaccinated people be satisfied with their vaccine? Like, if the vaccine works, why are you scared of unvaccinated people? That's the essence of this argument. And the answer to that question is because we have vulnerable people in our society for whom they will not receive the same protection as from the vaccine. So if someone is immunocompromised, so for example, you could have a autoimmune disorder, I think like lupus would be a good example, but there might be others, and you are on medication which reduces the effectiveness of your immune system, and you take a vaccine, your immune system will not mount the same response to the vaccine as a normal healthy person's immune system would, and you are still very much in danger through no fault of your own from unvaccinated people. It is people like this, as well as children in our society, that we are trying to protect from a deadly pandemic. And while the vaccine helps, it is not alone going to do the job. We also need to engage in responsible behaviors. And I think it is not a responsible behavior if you are unvaccinated to go into a gym and put people in danger. I think if you want to use things like public gyms and swimming pools, not public, but shared amenities, then you probably have a responsibility to take all steps that are available to you to stop yourself from becoming a vector for a deadly disease. And that includes taking a vaccine, just as being a responsible member of society. And if you don't want to take the vaccine because it's your personal choice or whatever, then don't be upset when the natural consequences of your decision is that you do not have access to these non-essential spaces like sports venues, because that's what's happening in this world right now. And you know, these sports venues are saying, no, we want you to be vaccinated. And you know, go to if you're going to go to a Raptors game, you're going to have to be vaccinated, and that's what people want. Catherine asks, on the topic of political canvassers, can we request proof of vaccination? I don't know, Catherine. That's a really good. I do not think you are allowed to refuse the political canvassers, and they're not going to use your gym. remember, when we're talking about proof of vaccination, we're talking about the non-essential areas of your condominium building. We're not talking about access to the lobby or the stairwells and things like that. But you can ask them if they're vaccinated, and you can feel free to scowl at them if they're not. Because honestly, like if you're a political canvasser and you are not vaccinated and you're going door to door talking to people, like that is wild to me that you would do that. So I get it, Catherine. I'm not sure you're allowed to not allow them access. I mean, people have to choose whether to answer the door or not when someone knocks on your door for political canvassing. But that's a great question, Catherine. That's like you really tied a nice bow on everything there for us. Oh my goodness, what a question. And someone says here, the risk to the canvassers too if they're not vaccinated. Yes, but they may not be they may be like COVID deniers, right? They might be people from a political party that says COVID's not real or something crazy. So that's what we're dealing with. Okay, what a question. All right. Okay, so let's just see. Do we have anything left here in the chat? Someone, Yelena asks, COVID is transmitted far more by droplets than surfaces. Why isn't there focus on emptying the room of droplets, especially in the gym where people are huffing and puffing and unmasked? I understand what you're saying, Yelena. Yeah, that's why I'm talking about the gyms, right? Because people are huffing and puffing and they are not required to wear a mask while exercising. So same as swimming pools. So those are the really areas that I think where you would want to focus your efforts as a rule. Francis asks, does taking a photo of a smoker caught red-handed in a non-smoking building's exclusive use common area, such as balcony, patio, parking, considered an invasion of privacy? Is it okay to take the photo for management action? I think it's okay to take a photograph if the purpose of taking the photograph is to provide proof that the person is breaching the rule. I think that's fine. Does someone have a reasonable expectation of privacy when they're outside on their balcony that someone might not photograph them? I think it's minimal, pretty minimal. So yeah, if you're using a photograph as proof of smoking, I do it all the time. And people might complain about privacy, but it's pretty rare. So I just have a little announcement here before we wrap up, having gone through all of the questions, which were, as always, excellent questions. So on August 12th, Mr. Horlick took part in a webinar on reopening amenities for condominium corporations, which was hosted by the City of Toronto Councillor John Fillion's office. Panelists included executive members of the Young Corridor Condominium Association, along with a representative of Toronto Public Health. And that webinar is going to be uploaded to our YouTube channel in the next few days. So watch out for that. That's a webinar with Brian Horlick and the City of Toronto Councillor John Fillion about reopening amenities. So more great information for everyone. Okay, we'll do a couple last little questions trickling in, and then we're gonna wrap it up. I hope everyone enjoyed the seminar. So question here, fan coil filter replacement guys are coming into my suite tomorrow. Can I require proof of vaccination before allowing them in? As a unit owner, you may have to allow access, or like I would say, tell your concern to your condominium manager so that steps can be taken to confirm it before they arrive at your door. I don't think it's reasonable just if you know they're coming, not to do anything before and then ask for them to show their proof of vaccination at the door. They're not going to be ready for that question. I would raise it now with your condominium manager and say, can arrange for this before they come so that the issue is resolved in advance, or else reschedule. And that's what I would do for you as a unit owner. My advice, try to get ahead of the issue and not just like refuse entry in the moment. And the end result of that is you might end up having to replace the fan coil filter at your own cost. And if you're willing to do that, then so be it. And finally, Charlene asks, with the balcony being exclusive use and a resident being nude, how do you deal with this as a violation? Proper attire to be worn in common areas. Okay, exclusive use balcony is a common element, but is not a common area. It is an exclusive area. And if you have a rule that says people need to, excuse me, I'm gonna sneeze. If you have a rule that says people need to wear proper attire on their own balconies, because it's like you can be seen by the public, then fine. But if your rule just talks about common areas, I don't think that would cover your balconies. I also misread this question of nude as rude. So that's where I'm going today. Yeah, I think people, if they're like flashing, that's something that would be considered like an antisocial behavior in a condominium. And there's a reasonable expectation that people are not going to be, I think, exposing yourself, not being topless, because topless is legal, but exposing your genitalia, let's say, is not a lawful behavior. And so I think you could reasonably insist that people, while on their balcony and visible to the public, ensure that they comply with public decency laws. There is a law about, like, it's not like voyeurism, but there's a law that says you have to be not indecent in public, and it's in the criminal code. And I'm not sure that this situation would breach that law, but if it did, then you'd be well within your rights to insist upon people being complying with the law. And I've had to deal with that. I've had to deal with people like having being nude and having sex with each other in common areas and stuff like that. So, and we reference that section of the criminal code that says you public indecency. Whew. All right, everyone. I think that's it for today. 70 minutes. That's a lot of me talking. So thank you all very much for your amazing questions. We've had a lot of interest on this topic of vaccines and rules and policies in condos. I think you can expect to see a lot more of this in the next days and weeks. And we want to do rules. So if people out there are interested in passing rules, please let us know, and we will be providing those rules. And if people want copies of the slides, again, let us know and we'll email them to you. We'll also have the slides and the article, which was attached to the email, in the video description when we post the video. That's all for now. We'll see you again next time. Thanks everyone for joining us. Again, if you missed any part of it, we'll be up on YouTube soon. Bye for now.